I'm rolling.
All right. Well, John, thank you for meeting with us today. First, can you tell me how you want to be, what your lower third, you'd like your lower third to say on the film? John Blume,
Uh,
director of.
Director of the Cornell Death Penalty Project.
Okay. All right. Cool. So we're 20 plus years from the Atkins decision, and we're still finding that states are finding ways to execute people with intellectual disability. Most recently, Oklahoma is like, kind of like taking over. They're executing a lot of folks. Where are we, and as a country, as it relates to people with intellectual disability and a death penalty? What are some of the things that you think about?
Well, as you said, in Atkins, the Supreme Court of the United States made clear that people with intellectual disability are not supposed to be executed, that they are categorically exempt, or they created a categorical bar forbidding their execution. The difficulty is, right, there's not like a blood test or something like that you can do to say who has intellectual disability and who doesn't. So it's so that determination has to be made on a case-by-case basis. Now, in many cases, the evidence is clear, and the prosecution will not seek the death penalty, and the person will either plead guilty to life without parole or at least face something less than the death penalty. But in other cases, sometimes actually even in very strong ones, the prosecution wants to persist and still seek the death penalty. And at that point, it becomes up to a judge, or in some instances a jury, to decide whether the person has intellectual disability or not. And I think that's where a number of cases, or some of the cases, I don't know what the best analogy is, but go off the rails, in part because of misperceptions that people have or stereotypes that people have about what a person with intellectual disability looks like. So it's obviously much better than it was before Atkins, but people with intellectual disability are still at risk of being executed.
Let me stop 1 second.
Okay. All right.
Cut that. Tyler. I'm rolling.
So John, you talked about some of the myths, stereotypes of people with intellectual disability. Can you just give us a brief overview of some of those myths and stereotypes that people get confused here?
Well, I think probably one of the most common myths and stereotypes about people with intellectual disability is that you can tell by looking at somebody. And I think this stems out of the fact that most people's exposure to people with intellectual disability is through people with Down syndrome, which is a genetic abnormality, which is visual, you can tell. But the reality is that overwhelmingly, the overwhelming majority of people with intellectual disability have no obvious physical manifestation of it. There's nothing that you can look at and see them. So I think that's probably the big one that you can tell by looking. But there are many others that, for example, that people with intellectual disability, can't speak coherently, that they can't read, that they can't pass the first or second or third grade, that they can't have a normal social relationship, that they can't drive a car or get a driver's license. And I could go on, but you get the point. And so the reality is that people with intellectual disability can do all those things that I just mentioned. Not every single one, and maybe not all of them, but there are people with intellectual disability who have been charged with capital offenses who have been able to do all the things that I've mentioned. And so I think what then happens is that because of those stereotypes, sometimes judges or juries think, well, this must not really be a person with intellectual disability.
So how do you fight against that? Because people are using their own prejudices and what they think intellectual disability looks like. I mean, how do you guys deal with that? I mean, of course, there's an educational part of this, informing people, and of course, your book does an excellent job at educating folks. But what do you guys really do to try to help that change the thoughts that people have?
Well, I think one of the ways that good capital defense lawyers and capital defense teams try to deal with the stereotypes that people have about persons with intellectual disability in capital cases is to try and educate the judge or jury. This is often done through utilizing what I would call a teaching witness, somebody with expertise in intellectual disability, maybe someone like Mark Tassay, who I co-authored the book with, or any number of people out there with expertise in intellectual disability who's not involved in the case, right? It's not evaluating the person, but just to come in and talk about, well, what does intellectual disability look like? What can people with intellectual disability do and can't do? And explain that people with intellectual disability, like all the rest of us, they have strengths and they have weaknesses. There are things they can do and there are things that they can't do. So I think it's largely an educational mission. It's more difficult in some cases than in others, and it's more difficult with juries than judges often. But I think that's the task, educational. And then also I think it's important for there to be a robust literature that people can read about it, where this is discussed in educational journals and law journals, so that people have sources to rely upon when trying to persuade people, or just the truth about what people with intellectual disability can and can't do.
And that kind of goes into, educating folks that, you're talking about, literature, you're talking about really explaining the intellectual functioning deficits, the adaptive behavior deficits. Can you talk a little bit about that, as far as some of the highlights of that, key points as far as intellectual functioning and adaptive behavior functioning?
All right, well, one of the things that makes the categorical bar for people with intellectual disability different than other categorical bars to the death penalty that the Supreme Court has created is that intellectual disability is a diagnosis. It's a psychological diagnosis that it's not a medical legal construct. It's a psychological diagnosis. And so it has established criteria. And intellectual disability has 3 criteria. The first one is significantly sub-average intellectual functioning. The second one is significant deficits in adaptive functioning. And the third is onset during the developmental period. Okay, so what does that mean? Let's go back and go through them one at a time. Significantly sub-average intellectual functioning means generally that the person functions in the bottom 2% of the population, measured primarily with what we would call an IQ test, an intelligence test. And so that would be an IQ of approximately 75 or lower. This is really, I think, one of the things that sometimes people get confused about. This is primarily a statistical concept. IQ tests are done, you've probably seen it, or people watching this have seen a bell curve, which has a distribution.
Let me stop you real quick. We got a light back there.
Okay. Sorry about that.
No problem.
You can start. You'll be fine starting with the sentence you were just starting on.
It might be the dimmer.
That's what I'm wondering.
I'm not sure. We have another dimmer we can try.
Do we have another one? Let's swap
Yep.
that out real quick. Sorry about
It's good and old. Another one.
Yeah, that's all. Yeah, that's about the same spot.
Hold on. Dial it in.
Oh,
Myself.
that's the danger with not having
Not
that
having a
table.
table in there. I do it in my dining room all the time when we moved our table out the way.
Yeah, it's a low hanging lamp. I know that hurt.
That'll leave Bruce. Alright. Yeah, that looks
I think it looks
pretty similar.
close,
Yeah.
Okay. All right. Sorry about that.
Okay.
So we were talking about the intellectual functioning, adaptive behavioral deficits and things of that nature. So if you can continue, or I can ask you the question again.
No, it's fine.
Okay.
So intelligence is across the population is measured primarily by IQ tests. People have heard about IQ tests now, but so an IQ test, generally people have seen bell curves, they know what they mean, and so they're normed, at a average IQ of 100. And so somebody with intellectual disability is someone who is 2 standard deviations below the mean. I know that sounds technical, but basically the deviations are 15 points in each direction, so 85, 70. But the short answer is what it's meant to capture is the bottom 2% of the population, or the bottom percent of the population who are disadvantaged in relationship to everyone else in the population. And so, on the other hand, right, IQ tests are not absolutely precise, right? You can't say, okay, somebody scores a 70. It doesn't mean that their IQ is 70 and is always going to be 70, right? There might be a little bit of variation. Any instrument like this has what's called a standard error of measurement about that. But to satisfy prong 1 under the Atkins definition, somebody has to have an IQ 2 standard deviations below the mean, or approximately 75 or below. There are some other things that we can talk about more on that if we need, but that's the basic gist of it. And then significant deficits in adaptive functioning, that's really just a scientific way of saying, how does the fact that this person has this low intelligence, how does it function, how does it affect, how they actually function in the world? And there you look at things like, well, what are the person's weaknesses? What can't they do? Are they able to live independently or not? Right? Many people with intellectual disability have really never been, not all, but many have never been able to live, independently. Does it affect their ability to communicate with people and their relationships with people in the world? Does it affect their ability to take advantage of the things that other people can take advantage of? Can they, for example, figure out how to use the bus system or to use the subway or to get around? What kind of work are they able to do or not do? Are they only able to do what you would normally think of as some kind of menial task or something? What are their limitations in employment? So it's just a way of assessing how these people, somebody with this low intelligence, is able to function in the world. And then the third prong is onset during the developmental period. And what that means is that intellectual disability is, if you look at the psychological literature books, it's what's known as a developmental disability. So it's something that manifests in childhood. So for example, if I left here today and on my way home I was in a horrible car wreck and had a massive head injury, and my IQ was 65 after that because of the damage to my brain, and it really affected my ability to live in the world, I still wouldn't be a person with intellectual disability. I would be a person with a traumatic brain injury because that didn't happen to, I wasn't born with this, or it didn't manifest during the developmental period. It happened when I was in my 60s. So those really significantly sub-average intellectual functioning, existing with deficits in adaptive functioning, and manifesting during the developmental period are the 3 criteria for intellectual disability.
That's interesting as far as, if you had like a head injury or some type of trauma after the age of 18, that's not considered, you wouldn't be considered intellectually disabled if you had like an IQ of 65, like you said. Why is that? Because it seems like, I've read this, that Lisa Montgomery, who was executed, I think 3 years ago, she committed her crime, and but she had some type of trauma. There's a guy named Matthew Reeves down in Alabama, spoke with his mother, interviewed her, and she said that he was shot in the head, which she thinks greatly contributed to. I mean, of course, these are what people are saying. I mean, I don't have any, medical experts, telling me that. But, are we looking at it the wrong way, or is this just the way that it is? I mean,
Well, part of the reason this works out this way in the intellectual disability context is the idea of intellectual disability has existed for centuries, really in various forms, and it is a diagnosis intended to capture people for whom this has been a lifelong struggle. And that's why, for example, and a lot of this has to do with education. I mean, we have programs we used to call this mental retardation. So you have programs for slow learners, programs for people who are, quote, educably mentally retarded, is what historically we talked about. But so it's intended to capture people for whom this is a lifelong problem. And so that's how the diagnosis and the criteria were developed. In part to create services, in part to create educational programs, and other ways to help people with intellectual disability assimilate and reach their potential. And so when the Supreme Court created this bar, they just relied upon the diagnosis and the diagnostic criteria for intellectual disability. So a person who suffers a brain injury like we were talking about, now that would still be what we would call mitigating evidence, right? That you could present on the person's behalf and say, if they after this they commit a capital crime, say, well, look, they're not as morally culpable as someone who doesn't have this type of brain injury. The jury or judge might or might not accept or believe that, but they still wouldn't meet the criteria for intellectual disability.
and they probably would not get Atkins relief.
They would not be eligible for Atkins relief. Right. There's been some work on it, can you extend this for the common sense reasons that many people suggest. Well, the person, maybe they didn't have it at the age 22 or 18, depending on where you draw the line in the developmental period, but in most other respects they suffer from the same disadvantages that somebody with intellectual disability does.
So when we're talking about intellectual disability, and we're talking about, you were talking about the bell curve and everything. There's something called the borderline intellectual functioning. Can you explain that a little bit? Because it seems like most people, there's a lot more people across this country that are in that borderline area than we actually think.
Mm-hmm. Well, yeah, the term borderline intellectual functioning has somewhat fallen out of favor in recent years. But nevertheless, what it means is that in a number of these cases, the person who either has an intellectual disability or doesn't might be what you would call close to the line. And if you think about it, that's not that surprising. I mean, people who have very severe intellectual disability, they're not going to be out in society and commit a capital crime. Many of them are institutionalized because they can't walk, they can't talk, they can't, function. Somebody with an IQ in the 40s, or low 50s is not going to really be out in the world in a capacity where they would even have the not only just the ability to live in the outside world, but to commit a crime of any kind, much less a capital crime. So in general, the people where this is going to be a question are going to be people whose IQs are in the mid 60s to low 70s, or maybe 65 to 75, somewhere in that range. In those instances, often it's going to be a question of clinical judgment by a mental health professional on which side of the line does this person fall on. Now, the consequences of that are profound. right? If someone falls on the intellectual disability side of the line, then they aren't, at least in theory, subject to the death penalty. Yet they fall just on the other side of the line, at least according to the evaluating experts, they would be subject to the death penalty. But in reality, right, the person's ability to function in the world, it's not like 2 IQ points suddenly change the world for somebody and they can go from being somebody who couldn't get a GED or graduate from high school to graduating from Harvard. That 2 IQ points doesn't do that for you. So it's it is a matter of line drawing, and sometimes it can seem somewhat arbitrary and capricious. But because this category is tied to the clinical consensus criteria for intellectual disability, there are going to be cases that are, what you can call just a near miss or just outside the range, or what we used to call borderline intellectual functioning.
So it seems like, there's some areas that we could get into as far as bias. Whoever's evaluating the person with ID, how much does bias play into these evaluations, if any? I mean, if it does.
No, there are a number of cases, I think, where, I think bias can operate at multiple levels in the system. One set of biases would be, expert selection. Are you selecting experts who are predisposed to determine that somebody, for example, doesn't have intellectual disability? In Alabama, for example, you mentioned the Matthew Reeves case. In that case, in a number of other Alabama cases, there's been an individual named Dr. King who has testified for the state of Alabama repeatedly. And I don't think he's ever seen somebody that he thought actually had, or that at least he was willing to admit had intellectual disability. Right? He is a go-to expert by the prosecution in Alabama cases because they're confident that he's going to look at the data and conclude that the person is not a person with intellectual disability. And in a number of different states, there are these types of what I would call go-to experts that the prosecution often utilizes in cases where we call them Atkins cases, or cases where it's a question of does this person have an intellectual disability. So that's one source of bias. Another one, not completely independent of that, would be judicial bias. That there are some judges who are resistant to finding somebody is a person with intellectual disability. Now, some of that might have to do with things that we've already talked about, like stereotypes. But some of it, I think, is due to a large number of judges in state court and in federal courts are former prosecutors, so their sentiments are often aligned in that way. Or they're also, in many instances, elected. And so they have to face the voters. And it's generally not popular to find that somebody who has committed a capital crime, and often, I don't want to minimize, often the crimes that people have committed are horrific. They're all murders, and someone has been killed, often brutally. And so there can be a hydraulic political pressure to find that the person doesn't have intellectual disability, so that it doesn't look like they cheated the executioner or didn't have to face the death penalty. And then the same thing can be true in cases or in jurisdictions where the question is left to the jury. And because we have seen, there have been a number of studies of this, that juries almost never find somebody to be a person with intellectual disability. I think in part that is again because of various stereotypes of what people have. But I think it's also hard for someone to do because a jury normally would decide the question of intellectual disability at the same time they're deciding whether this person should be sentenced to death. And so what some of the studies have shown, and some of the studies that I and my colleagues have shown, is that the jurors aren't able to separate out the question of, does this person have intellectual disability, from does this person deserve the death penalty. What they more or less decide is, does this person deserve the death penalty? And then they retrofit the intellectual disability question to that end. So if they think, okay, this person doesn't deserve it, they find that they have intellectual disability. If they think they really do deserve it, then they find they don't have intellectual disability. So I think there are multiple places in the system where both stereotype and bias can operate, and that in part explains why people with intellectual disability continue to be sentenced to death and executed.
You know, it's interesting when we're talking about the Matthew Reeves case and talking with Matthew's mom and some of the attorneys that tried to help him on appeal. What's interesting is that I think I got this correct. In the state of Alabama is the only state where the governor can go totally against what the jury has decided. Meaning that in the Matthew Reeves case, the jury decided that, okay, he shouldn't be executed because there's evidence. But the Governor Bailey, came back and said, no, we're going to execute him anyway. I mean, is that something that usually happens, across the country, or is it at the governor's discretion, or how does that even happen if the jury says, and maybe this is something a question for somebody else, but it just popped in my head, but I just thought that was kind of weird, kind of backwards.
Well, so to be clear, what it happened in Reeves and what has happened in other Alabama cases isn't the governor, but it's judicial override. So Alabama had a system, only a few states had this, where the jury's decision wasn't final. The ultimate sentencer was the trial judge, and Florida had this system too. So it's frequently called judicial override. And what it means is that the jury's verdict was considered to be a recommendation. And the judge could say, well, I understand all that, but and I understand they recommended life, but I'm going to impose the death penalty. Now, what's ironic about this is when this was put into the system in Florida back in the 1970s, it was intended as a safety precautionary measure. The belief was, well, juries might sentence somebody to death based on racial bias, or they might have some other kind of bias, and so we're going to give judges the power to override the recommendation in case of injustice. But that's really just not how it played out. Almost all the overrides, both in Florida and in Alabama, were when a jury recommended life, and a judge would then ignore that and impose the death penalty. So Reeves had a life majority recommendation, which was overridden by the judge, and that's happened in a number of other cases as well.
Okay. Thanks for clearing that up. That's good. So let's go back to the Atkins case, and what do you think the Supreme Court got right? What do you think they got wrong? What are some of the, some of the open doors that we still have here that cause some problems for people seeking Atkins relief?
Well, what the Supreme Court got right in Atkins versus Virginia, what the Supreme Court got right in Atkins versus Virginia was the conclusion that people with intellectual disability had significantly decreased moral culpability and shouldn't be subject to execution. What they also got right, but didn't say quite strongly enough, was that because this is a psychological diagnosis because there are agreed upon clinical diagnostic criteria that they should be followed. What they got wrong and has created much of the litigation after that and has created opportunities for people with intellectual disability to be executed is where they said in the opinion, well, as we've done in other contexts, such as competency to be executed, we leave it to the states to enforce the categorical bar. And so when I first read Atkins, when I came out, obviously I was happy that the Supreme Court had created a bar. But even then in reading that, I went, this is going to cause problems. That we're going to leave it to the states to decide how to enforce the mechanism. Because what some states did, I think Texas is a great example, Florida is another good example, is they interpreted this as giving them the license to either ignore or modify the diagnostic criteria for intellectual disability about this. And that's why, for example, Florida, in a case not long after Atkins was decided, created what we're going to call, what I think is best easily understood as a rigid IQ cutoff. So if you didn't have an IQ below 70, then you couldn't be determined to be a person with intellectual disability. But no person doing an evaluation, legitimate mental health professional doing an evaluation, would agree with that. That's not the way it's done because this IQ tests aren't that precise. So somebody could have an IQ of 72, 73, 74 and still, given the standard error of measurement, meet the first criteria, the first prong, significantly sub-average intellectual functioning. Texas did in a different direction, and they created, in a case called Ex parte Briseno, created what came to be known as the Briseno factors. And what they said is that they were actually fairly explicit about this, and they said, well, we understand that what the Supreme Court has said this, but we think we need to create criteria that people in Texas will agree with. And while, everybody can agree that Lenny and John Steinbeck's of Mice and Men shouldn't be executed, those we're going to establish these other factors for people to look at. And many of these were based on raw stereotypes, such as, does the people that this person grew up with, did they think he was a person with an intellectual disability? Did the person, was the person able to talk to law enforcement? Just a number of different things that were steeped in stereotype. And then other states, did other things. And in a few instances, the Supreme Court has fixed this. They got rid of Florida's strict IQ cutoff in a case called Hall versus Florida. And they got rid of the Briseno factors took a couple tries, but they did it in Moore versus Texas before the Texas Court of Criminal Appeals got the message on this. But that language has, over the last 20 years, I think, created the most problems in that. And you're, in some degree, continuing to see that now that we're 20 plus years post-Atkins.
So I would imagine that after Atkins, many of the lower courts, how they say, felt some kind of way about the decision. Could you kind of give us a broad perspective of, what the feeling was after Atkins by some of the lower courts, some of the attorneys and things of that nature?
I think that, so what you saw after the Supreme Court's decision in Atkins is it was in some ways similar to what you've seen after other significant Supreme Court decisions, especially Supreme Court decisions related to the death penalty. When in 1972 the Supreme Court invalidated all then existing death penalty statutes in Furman versus Georgia, if you would have read the papers the next day, you would have thought, well, nobody's ever going to be safe to walk the streets again. That there's going to be murder, mayhem, rape, and robbery, and nobody can do anything about it because the Supreme Court has said you can't have the death penalty. Now, of course, none of that happened, but the Supreme Court did eventually reinstate the death penalty. But I think a similar thing happened after Atkins. People, there was, while many, especially advocates in the field, advocates for people with intellectual disability, and many others thought, okay, the Supreme Court did the right thing here. People that have this significant a disability should be executed. But there were others who thought, well, you're just letting people who aren't that smart off the hook here. Because they can only serve life without parole now about that. But so, no, there was, and then the general complaint was, no, this should be left up to judges and juries to decide on a case-by-case basis. You shouldn't create a categorical bar for them, for these people. But of course, one of the reasons the court said we are going to create a categorical bar is that they believe that because of, correctly, I think that because of stereotypes and because of these other reasons and concerns about future dangerousness, it really couldn't be decided on an individual basis which people with intellectual disability should be subject to the death penalty and which shouldn't. I think that was part of the general reaction, and some of that has also persisted to this day.
And you may have answered a little bit of this, but I'll ask it a different way here. How have we evolved since Atkins versus Virginia? How has the legal landscape evolved since that? What are some of the things you think we can do to change this? To kind of change what the states are continuing to do, and some states continue to put people with intellectual disabilities on death row and ultimately executing them. So how has the legal landscape changed, and what are some of the things that you think we can do that the average person or advocacy groups or what have you could do?
Well, I think one of the main things that's changed is, since the court created Atkins, is many people with intellectual disability aren't subject to the death penalty anymore. Either the cases are resolved through plea bargaining or disposition beforehand about that. So that's changed. I think and then I think generally for both prosecutors and defense lawyers who are involved in capital cases, I think everyone now has a more sophisticated understanding of what intellectual disability is and isn't than they did before. But what we haven't been able to sort of fix is there's still a number of people who I think clinicians would clearly agree are people with intellectual disability who still get sentenced to death and still get executed because of stereotype and bias. So we haven't been able to root that out completely. I think what could be done to help improve this, one would be better funding for the defense function, right? In many states, the defense team has inadequate access to funding to hire qualified experts who can do some of the things that we've been talking about, come in and educate a judge or jury about what intellectual disability is and isn't, what it looks like and what it doesn't, and or possibly to create specialized teams, defense teams and lawyers who deal with this on more than a case-by-case basis. I mean, sometimes, right, in a capital case, it might be the first time this lawyer has ever had a case where there was a person with intellectual disability subject to the death penalty. Well, one of the things we know about this is, there's a learning curve about this. And so if it's that person's first case, right, they often either There have been cases where they didn't even identify the person as a person with intellectual disability because they didn't kind of know what they were looking for or know how to develop and present it, or the presentation was inadequate because they didn't really, either because they didn't do an adequate investigation because they didn't have the resources for that, or the sophistication to understand what they were looking for, or the ability to hire qualified experts who could come in and testify about this. So I think the better funding for the defense function, making sure that the lawyers that are appointed in the case have experience with people with intellectual disability could all make a significant difference. And then I think in those states that still allow the jury to decide and don't allow for judges to decide in a pretrial context, I think changing that would be a significant step forward. We have seen, for example, Georgia is a good example. Georgia, the defendant has to prove beyond a reasonable doubt to a jury that he is, they have guilty but retarded or guilty but a person with intellectual disability. The reality is that in contested cases, no one in Georgia has been able to satisfy that high burden. It is a crippling burden of proof, and putting it so both putting the burden on the defendant to show that he is a person with intellectual disability and leaving the decision solely in the hands of the jury has meant that, at least in contested cases, Atkins is really not a reality in the state of Georgia. So those are some procedural issues that also, if the court were to fix them, would make a difference. So to remove the decision from the jury as the only decision maker, and eliminating some of these onerous burdens of proof.
It's interesting.
Let's stop you one second. Stop, first, pop that card out. We're rolling again.
Okay. So let's talk about some of the skills and strategies that attorneys should have or need to have, or some of the things they need to keep in mind when representing people with ID. What are some of the things that come top of mind to you when we talk about that?
Well, it's essential that an attorney in a case where intellectual disability is at issue has a thorough and sophisticated understanding of the diagnostic criteria for intellectual disability. So that means they have to have an understanding of intelligence tests and how they work, and understand things like basic sort of concepts like the standard error of measurement, which is present in any intelligence test, or that they understand the significance of aging norms, which it basically just means that as you have an IQ test, the longer it is in existence, scores on that go up. And so because of that, somebody who actually meets the first criteria might have an artificially inflated IQ score. But you also have to understand, well, what's a real IQ test and what isn't. For example, if you look at school records, they'll often have, they'll report something that might look like an IQ score, but it's really not about it. So you have to have an understanding of what is what is a legitimate, the phrase is sort of gold standard IQ test, and what isn't. So you have to have an understanding of that. And also, an understanding, or somebody has to understand things like how school educational systems work, about that. For example, in many school districts, there's a reluctance to label a child as a person with intellectual disability. And that comes from a good place in many ways, is they don't want the child to be stigmatized. Or it might also be that the parents are resistant to it, that they don't want their child to have a diagnosis of intellectual disability because they're afraid it will stigmatize them and hold them back. If you're not sort of aware of that, then later on, if you're looking at school records and they say something like one of the terms we mentioned earlier was borderline intellectual functioning, or maybe they says has a learning disability, that in fact might mean that everyone really thought that was a child with intellectual disability at the time, but they didn't give them the label. So I think, that to adequately represent someone, you have to have an awareness of a lot of different things about intelligence tests, school systems, and how they work. And that's just on the first prong. On the adaptive deficits functioning, I think an important concept that people need to be aware of is that the focus is on weaknesses as opposed to strengths, and the recognition that even people with intellectual disability are going to have things they can do well. They're going to have strengths. It's not all weaknesses. And then it's also a matter of looking to see, when assessing intellectual functioning, is figuring out, well, where did these people's support come from? Because some people with intellectual disability have gotten along pretty well in life because they had a strong support system. Right? Either they had maybe they had a brother who was a person that didn't have intellectual disability, who made sure they got up on time, made sure they brushed their teeth, made sure they caught the bus, about this, or had a teacher that kind of looked out for this person and helped them kind of navigate, the world. So I think it's understanding that strengths coexist with weaknesses, that it's the deficits that matter, but trying to get a detailed, sophisticated understanding of what this person's life was actually like. Because one of the mistakes that people often make is they will take the person with intellectual disabilities' word for, the person facing the capital charges, word for what they can and can't do. And these people often aren't reliable historians. Could you cook? They might say yes, and then if you sort of try and figure out, well, what could they really do? And what for them cooking might be, well, maybe they could put something in a microwave about it. But they often don't have an understanding of their limitations, or they're not honest about them. Because, one of the things we've seen in case after case is this has been a source of shame, for people their entire, lives. They've been called stupid, retard, different, idiot, moron. They've had all these labels attached to them. And many of them have become quite good at what I think what I would refer to as masking their disability, or what some experts call the cloak of competence, that they're able to appear because this has been a source of shame, to function at a higher level than they can, to hide their disability.
There's a flickering
Yeah,
light. I'm sorry about that.
I think it's the air conditioner kicked up a degree, and I'm wondering if we got a power source that is fluctuating here. I wonder if we can pull this cord out outside or something.
Yeah, I think we forget sometimes that people with ID, they want to fit in.
Mm-hmm.
And you were speaking on that, so let's move forward with that.
Well, one of the things that people with intellectual disability are very good at is hiding or masking their disability. And there's a literature on this, which is called the cloak of competence. And all that just really means is that many people with intellectual disability are very good at hiding that because it's been embarrassing for them. For example, I had my first client who was a person with intellectual disability almost 30 years ago, maybe more, 30 years ago now, was a person named Lemmy Arthur. And one of the things that he figured out was, in his very simplistic view, was that people with that smart people can read, and he was actually illiterate. He couldn't read at all. But what he was able to do was to memorize some different verses in the Bible and then find them in the Bible and then use his finger to go along. And so when I told him, when I said, Lemmy, we're going to present it, this was back when it was called mental retardation. And I said, Lemmy, you got to understand, we're going to have people talking about you and they're going to say that you have mental retardation. And he got very upset and actually said, I don't have mental retardation. He said, no, he said, I'm not retarded, I can read. And I said, no, you can't read. And he said, no. And he pulled out his Bible and he went to the 23rd Psalm and he pretended to read it. Now, that's an extreme example in many respects, but it is, I think, a illustration of the lengths to which, people will go to hide it, to mask it, or there are, other people who, for example, always have to go the same way to work to do this, or something, like that. But it's just what it means is that there's this myth or misconception that people with intellectual disability, people are going to fake, have an intellectual disability to avoid the death penalty. In fact, I'd say the opposite is true. In many cases, there are some people who almost would rather die than have somebody say, they have intellectual disability because of the stigmatizing label and the shame that has followed them their entire lives after this.
Yeah, I remember reading, I think in their dissent, Justice Scalia was concerned about that people would fake. And I was like, how would people fake if you have, I just never understood how you could think that way, but it's good, cool. Let's talk about race and how race plays a factor into this discussion about people with ID, and how does it play a factor in this, and what are some of your takeaways, some of your thoughts about that?
Well, I think more in the last, 10 or 15 years or so, there has been, race has played a significant role in some cases where intellectual disability is an issue. And I think it's happened in two different ways, at least two different ways. I'm sure anything, whenever you talk about the race and the death penalty, it's a very complex conversation.
1 second here, that airplane here. Let me know when you're good, bro. All right. So let's continue our discussion about how race plays a factor into these things, into these Atkins cases.
Well, so whenever you talk about the death penalty, race is an issue at multiple levels, but specifically in the intellectual disability / Atkins context, we've seen it play a role in at least two different ways in recent years. One is on the question of IQ scores. So there has been, so we've seen prosecutors, for example, say, and some of their experts say, well, look, IQ tests are often racially discriminatory. So this person is black. And so, yeah, they got a score to 70 or a 68. But because these tests are discriminatory, we should add points to their score. It's like some really bizarre affirmative action death penalty program that they have going on. Now, there are a whole bunch of reasons that's not appropriate to do. And I don't even think that these people that advocate for that really believe it. It's just a means to an end, which is to try and ensure that the person is executed. So that's one way on the significantly sub-average intellectual functioning prong. The other one is really on the deficits in adaptive functioning prong. And this is where there will be things said like, or you're like, well, no, this person doesn't have deficits in adaptive functioning. They were just raised poor and black. And so because of that, that's the reason they couldn't do A, B, C, and D about this, because they were, raised as a poor black child in Mississippi or Alabama or sort of wherever it is. And you saw this in Bobby Moore's case and some other cases like that. So I think it's an attempt to try and attribute either the low intellectual functioning or the deficit in adaptive functioning not to race, and say that it's really race is the explanation, not that this person falls within the diagnostic criteria.
So I want to get your opinion on, and correct me if I'm wrong, from what I've read, it seems like there's some restrictions that the Supreme Court has put on habeas remedies and things of that nature. And how does that affect people seeking Atkins relief in this broad context here?
Well, the Supreme Court of the United States has made federal habeas corpus relief, which has been one of the primary places where people sentenced to death have gotten new trials or new sentencing hearings, much more difficult to obtain. And this has happened through a series of decisions interpreting what is called the Anti-Terrorism and Effective Death Penalty Act of 1996, or EDPA is how it's frequently known. But the simple version of this that I think anybody watching this will be able to understand is that it's not enough if you go into federal court. So by the time you go into federal habeas corpus relief, for example, let's think about a person who has an intellectual disability. They were tried, convicted, and sentenced to death, and then maybe intellectual disability was an issue, maybe it wasn't. But it might have come up in what's called state post-conviction proceedings or of that. But a state court is normally going to have decided the issue adversely. Those that are going to have found that this is not a person with an intellectual disability. And so then when you go into federal court and are seeking federal habeas relief, there are new restrictions on this. And you have to show not just that the state court decision was wrong, but that what the state court did was so unreasonable that no jurist of reason could agree that the state court decision was correct. Well, that's a very difficult burden to meet about that. So what you see are cases where the evidence for intellectual disability is, I think, objectively overwhelming, but the state court said no, and then the federal courts will say, well, if we were deciding this on our own, we would say this is a person with an intellectual disability. But because we're not, and because the state court said that he wasn't, then we don't really have the power to set that aside. A good example of this is Danny Hill's case out of Ohio. So prior to his capital trial, which took place prior to Atkins, Danny Hill had been found to be a person with intellectual disability, or what at the time was called mental retardation, more than a dozen times. From kindergarten on, he'd been found to be a person with an intellectual disability. He'd been in special ed classes. His IQ had been tested numerous times. It was always in the range for intellectual disability. So he was in special ed his whole life. At the time of his capital trial, which was before Atkins, he was evaluated by multiple experts, and everyone agreed. Even the state's experts said, yes, this is a person with mental retardation. And then after Atkins was decided, the state court said, well, wait a minute, hold on, here. And they were able to find, an expert to say that Hill didn't meet the criteria because of his prison functioning, because of how he was done in prison. Well, that's an illegitimate way to do it to begin with, because somebody in a maximum security prison trying to figure out what their adaptive functioning level is there is you can't get a reliable assessment of that, right? It's not like what do? They get up when people tell them to get up. They eat when people tell them to eat. They eat what people tell them to eat. They take a shower when somebody tells them to take a shower. It's pretty easy for a person with intellectual disability to function within the structured environment of a maximum security prison, especially death row. But because of his prison functioning, the state court says, well, okay, he loses on his Atkins claim. And then he goes into federal court. Twice, federal court said that he won, but the Supreme Court ultimately said, well, what the state court did here wasn't so unreasonable that all jurists of reason would do this. So, there's still, his case is back pending in state court, but I think that's an illustration of the obstacles that people that are challenging adverse intellectual disability decisions in federal court face.
So, and I wonder, are there many issues or many examples of things like prosecutorial misconduct that happens in some of these cases? I think I was reading about one case where prosecutors did not provide or withheld some information or evidence that they had that actually would have exonerated someone. Are there many cases like that? Have you found that there are many cases where you have that?
Well, in the death penalty in general and death penalty litigation, there have been two primary reasons that death sentences get set aside. The first and most common is ineffective assistance of counsel, that their lawyers performed inadequately. The second is prosecutorial misconduct, which comes in, when you see it, it comes in two different flavors or two different varieties. One is what I would call misconduct in closing argument. In other words, they say a bunch of things that are inflammatory or racially inflammatory that they shouldn't say. The other is the withholding of exculpatory information. They fail to disclose information to the defense that's in their possession. Now, in some instances, this could be information about that goes to guilt or innocence. This person really do it. There was a case, Earl Washington in Virginia many years ago, and there the prosecution withheld evidence about the race of the perpetrator. Their eyewitness had identified the person as white, and Washington was black about this. So, but there have also been instances, specifically in the context that we've been talking about, the Atkins versus Virginia context, where either information has been withheld about a person's reports that they had about the person's adaptive functioning, or maybe that they had an expert evaluate the person and they concluded he was a person with ID and they didn't disclose it. They tried to bury, that report. I don't want to mean to suggest that happens, in every case, or that happens, all the time. But there are clearly documented instances where it has happened.
So, let me ask you, as far as protecting people with ID, I think we touched on this a little bit. Any other thoughts about how we can protect people with ID who find themselves in these situations and that are seeking Atkins relief? Any ideas? Any other ideas?
I think we've talked about many of them. I think it's important to have adequate funding. It's important to have attorneys that are competent themselves and have sophisticated understandings of intellectual disability. It is important to eliminate some of these procedural obstacles that we have. That could be who has the burden of proof and what is it. About that, the burden of proof is now on the person who says they have intellectual disability. One thing that potentially could be done is to shift that, and if there's an allegation of intellectual disability, the prosecution could have the burden to prove that they don't have ID. And then there's also this question of the limitations on federal habeas corpus relief, and could you modify, change the jurist of reason standard. So there are a number of different things, both substantively and procedurally, including making sure states follow the diagnostic criteria, which they still deviate from in some respects, which could help reduce the risk. You're never going to eliminate the risk. You're never going to anytime there's a line, right, sometimes you're going to get it wrong on which side of the line that something falls on. But I think now we currently have a system where there are too many impediments and too many opportunities for a case to kind of go off the rails a little bit, where intellectual disability is an issue.
Well, I just have two more questions. They'll be really quick. You kind of mentioned, proceduralism. How does that? Because I remember something. I believe Brian Stevenson said. He said that the courts are more concerned about procedure than they are about getting at the truth. I'm paraphrasing, of whether or not this person has intellectual disability and do they meet the Atkins criteria. Can you speak a little bit about that and what your perspective on that?
Well, I would agree with the observation that in many cases the system is more interested in, is not necessarily interested in getting to the truth of whether this person is a person with intellectual disability or not. And that often it really turns on, well, do I think what this person did was sufficiently heinous or egregious that they should be sentenced to death, regardless of whether they are a person with intellectual disability. And I think the way this manifests is in pushing cases through to trial or hearings where the evidence seems overwhelming, and hoping that you find a judge or jury who will reject the claim, appeals to stereotype, bias, and in some instances racial prejudice, and then these other finding that the claim wasn't raised properly and is procedurally defaulted, which is another problem, or finding that the claim was raised too late, or finding that, because the state courts rejected it, that there's nothing the federal court can do. All of these things are really, ways to avoid facing the bottom, what in my view should be the bottom line question is this a person with intellectual disability or not? And if they are, and if you're faithful to what the Supreme Court said in Atkins, that person shouldn't be subject to the death penalty.
Cool. And the last question is, what haven't we talked about in this debate about people with ID and the death penalty? Any other things that you want people to think about? Anything else? Maybe something I missed. Maybe, you guys, you have any questions?
I do have a question. You're okay with that? One of the things that I hear people refer to is there's intelligence and then there's emotional intelligence. And sometimes someone's emotional intelligence may play a role in their control mechanisms in terms of how they act out on something or don't. Is that a factor in this, or does that fall under mental health?
Emotional intelligence would normally not be relevant to whether somebody has an intellectual disability or not, but it could be certainly relevant to do they have some other mental condition, or do they have some other inability to conform their conduct to either what you would call normal social norms or whatever. Now, normally people who have significantly sub-average intellectual functioning or meet the first prong of that, not in all cases, but in many, what I think you're referring to as emotional intelligence would be impaired as well. About that, but that's variable, right? There are people with intellectual disability who, can do feel a normal range of emotion in some things, and there are many that don't. So they're not exactly the same, but they too can be relevant in an individual case.
And I lied. I do have one other question, but it's probably going to be really short for you to answer. The Buys case, how did Atkins kind of influence the Buys case for you? I know it's a rather simplistic answer, but just wanted to get that.
Well,
that was one of your first, what your second case with someone with intellectual disability, or?
It wasn't my second case with someone with intellectual disability.
Oh,
it was, but it was one of the first. It was the first case I had in the Supreme Court of the United States, that argued in the United States Supreme Court, that was relevant to Atkins. I would call it an Atkins adjacent case.
Oh, okay.
And what happened there, I think, is a good example of some things that we've talked about, and I would refer to it as it was a good example of prosecutorial obstinance. Michael Bias, similar to Danny Hill's case, which we talked about, had been determined to be a person with, again, using the language of the time, mental retardation really his entire life. About that. His mother was also a person with intellectual disability, his siblings, and realized it was a case where intellectual disability had really gone back generations in this. And there was absolutely no question, about it. And he had been found on multiple occasions. At his trial, all the experts agreed that he was a person with intellectual disability, even the state's expert. He's convicted and sentenced to death on his direct appeal. The Ohio Supreme Court says, well, this is a person with intellectual disability, or at the time mental retardation, but nevertheless, that's not a bar to execution. In his post-conviction proceedings, he, pre-Atkins, said, well, things have changed now since the Supreme Court's previous decision in Penry. You shouldn't execute people with intellectual disability. And the Ohio Attorney General's office conceded, yes, he's a person with intellectual disability, but it doesn't mean we can't execute him. Then after Atkins was decided, he goes back to the state courts and says, all right, everybody's always said I'm a person. He didn't do it, his lawyers did, obviously. Went back and said, okay, the Supreme Court has said you can't execute people with intellectual disability. Everybody who's ever seen this person, including the Ohio Supreme Court, has said that he's a person with intellectual disability. Modify his sentence to life imprisonment. And the Ohio court said, no, we're going to force him to have to prove it one more time. And he then went to federal court and said, well, wait a minute, you should stop this, that I've previously been determined to have intellectual disability, and so double jeopardy should prevent the state of Ohio from litigating this issue again. And the federal court agreed, and so the case was heard by the Supreme Court on this issue. Now, they ultimately decided that the state of Ohio would get a chance to prove this again, and there would have to be another hearing on it for complicated habeas reasons. But what happened, and all of this was just a postponement of the inevitable, was that so we went back to state court. We went back to Cincinnati or Hamilton County, Ohio, and he was evaluated again by an expert who worked for one of the leading institutions in Ohio that treats people with intellectual disability, and an expert selected by the state, and they both agreed that he was a person with intellectual disability, and Michael Bias was removed from death row. So that's was how that played out.
Good. Well, Professor Blume, I don't have any other questions. Do you have anything that you want to add, or?
No, I think it's been a pretty wide-ranging discussion.
Yeah. Well, again, appreciate your time.
No problem.
I know you're very busy and everything.